Well, hey there, y'all. Welcome back to the Porchlight Patriot, the show where we read the law, call out the bullshit, and remind the Commonwealth that the Constitution ain't a damn suggestion. Tonight we're digging into Virginia Code Section 18.2, 308, 1 to 3, the statute that said, what if we took your rights, threw them in the trash, and blamed mental health paperwork based on a random unidentified call like it was the boogeyman? Now, before we jump in, let me set the scene for you. Pour yourself a drink, turn on the porch fan, and get ready. Because tonight, we're not just raising hell, we're filing a complaint with the Almighty.
Yeah, flip that porch light on. Time to see what kind of mess we're dealing with today. As I'm sitting in my rocking chair, calling out the bullshit, watching all these headlines, acting like a fool again. Southborn, truly torn, fed up and fired. If the country's lost its mind, baby, I'm getting inspired. I'm the Porchlight Patriot, shine it where it hurts, dragging all the nonsense out, the shadows and the dirt. If the world's gone sideways, I'm saying it loud. Bless your heart, fix your mess, and make your mama proud. Pull up a chair, y'all.
Under Virginia law, specifically Section 18.2 to 308, 1 to 3, it is unlawful for certain individuals to purchase, possess, or transport a firearm. This restriction applies to people involuntarily admitted to a facility or ordered to mandatory outpatient treatment, whether as adults or as minors age 14 or older, following a commitment hearing or a temporary detention order. The law also covers those who, after being temporarily detained, agreed to voluntary admission, and individuals found incompetent to stand trial and likely to remain so. Violating this prohibition constitutes a Class 1 misdemeanor, which is a serious criminal offense in Virginia. Anyone prohibited from purchasing, possessing, or transporting firearms under this law can petition the General District Court for restoration of their rights. This petition can be filed after release from involuntary admission, mandatory outpatient treatment, voluntary admission following a detention order, release from a training center, or release as specified by Section 19.2 to 169.3. If the person is not a resident of Virginia, the petition should be filed in the jurisdiction where the most recent relevant proceeding occurred. A copy of the petition must be delivered to the attorney for the Commonwealth, who can respond and represent the state's interests. The court will conduct a hearing if requested by either party and will consider evidence about the circumstances of the original disability, criminal history, treatment record, and reputation. If the court determines that the person is not likely to act in a manner dangerous to public safety and granting the relief would not be contrary to the public interest, the petition will be granted. If relief is denied in the General District Court, the individual can petition the Circuit Court for a de novo review. Upon granting relief, the court will enter a written order and the firearm prohibition no longer applies to the petitioner. After granting relief, the clerk of court is required to certify and forward a copy of the order to the Central Criminal Records Exchange using a specific form. The law also defines treatment record for the purposes of these proceedings, including copies of health records detailing the petitioner's psychiatric history. These records must cover the commitment or adjudication that is the subject of the request for relief, ensuring the court has a complete picture of the relevant mental health history. This law punishes people for seeking help. You walk into a hospital thinking, I need support, and the state says, great, while you're here, we're going to take your rights like a raccoon stealing cat food. And the wild part? Voluntary admission after a detention order counts the same as involuntary. So, you do the responsible thing and the law treats you like you're one bad day away from starring in a cautionary tale.
Sorry, ma'am. You can't buy a firearm.
Why?
Because you once sought medical help.
So I'm being punished for being responsible?
Correct.
Comedy writes itself, tragedy too. Due process means notice, hearing, evidence, and a judge. Virginia's law said, what if we skipped all that and just trusted the paperwork? This statute automatically reports you to the Central Criminal Records Exchange. No hearing, no lawyer, no chance to say, hey, that's not accurate. It's like being convicted by a fax machine. And then you have to petition to get your rights back. Imagine if the DMV took your driver's license because someone thought you might speed someday and then told you to prove you're not a NASCAR driver. Hell, at least NASCAR gives you a helmet. This statute violates both substantive and procedural due process. It presumes dangerousness without evidence.
Courts are increasingly striking down blanket bans tied to mental health treatment. They fail the Bruen test and stigmatize recovery.
And that's the heart of it. The state can't claim compassion while trampling liberty. That's like saying, I love you while changing the locks.
Virginia Code, Section 18.2, 318 1 to 3, criminalizes the purchase, possession, or transportation of firearms by individuals who have been involuntarily admitted to a mental health facility, voluntarily admitted after a temporary detention order, or ordered to mandatory outpatient treatment. The statute imposes a categorical firearm ban based solely on civil mental health status, often without any judicial finding of dangerousness, without adversarial process, and without the procedural protections required before depriving a person of a fundamental constitutional right. Under modern Second Amendment jurisprudence, especially District of Columbia v. Heller, 2008, McDonald v. Chicago, 2010, and New York State Rifle and Pistol Association v. Bruen, 2022, Section 18.2, 308, 1 to 3 cannot survive constitutional scrutiny. It lacks historical support, violates due process, and imposes a status based disability that the Supreme Court has repeatedly rejected. For these reasons, the statute is unconstitutional, void, and should be immediately repealed or struck down. Heller held that the Second Amendment protects an individual right to keep and bear arms for lawful purposes, including self defense. McDonald incorporated that right against the states through the 14th Amendment, making it a fundamental right nationwide. Because the right is fundamental, any deprivation requires heightened due process protections. Section 18.2308, 1 to 3 removes a fundamental right without a judicial finding of dangerousness. None of these proceedings require a finding that the person is dangerous, a finding that the person is mentally incompetent, adversarial evidence, representation by counsel, or the procedural safeguards required before depriving a constitutional right. A TDO hearing is not a criminal proceeding, not a competency adjudication, and not a finding of dangerousness. It is an emergency civil process designed to stabilize a person, not to adjudicate constitutional disabilities. Under Bruen, the government must show that a modern firearm restriction is consistent with the nation's historical tradition of firearm regulation. There is no historical analog for disarming individuals based solely on temporary civil detention, outpatient treatment orders, or coerced voluntary admission after a TDO. Founding era laws disarmed individuals adjudged insane through formal legal process, individuals who were actively dangerous, or individuals who posed a threat to public safety. There is no tradition of disarming people based on non adversarial emergency mental health holds. Because Section 18.2, 308, 1 to 3 lacks a historical analog, it is unconstitutional under Bruen. The statute sweeps in individuals who were misdiagnosed, individuals who were never found dangerous, individuals who were detained for observation only, individuals who agreed to voluntary admission under coercive circumstances, and individuals who received outpatient treatment for non dangerous conditions. A law that deprives a fundamental right must be narrowly tailored, and Section 18.2, 308, 1 to 3 is not. The Supreme Court has repeatedly rejected laws that impose disabilities based on status rather than conduct, as seen in Robinson v. California, 1962, Heller and Bruen. Section 18.2, 308, 1 to 3 punishes people for who they are, not what they have done. Virginia allows individuals to petition for restoration of firearm rights, but the Supreme Court has made clear that a restoration process cannot save an unconstitutional statute. A state cannot constitutionally deprive a person of a fundamental right first and then claim the deprivation is acceptable because the person may later petition to get it back. A statute that violates the Constitution is void ab initio, invalid from the moment of enactment. This principle is well established in cases like Marbury v. Madison, which said a law repugnant to the Constitution is void. Montgomery v. Louisiana also confirms that unconstitutional laws are void and must be disregarded because Section 18.2, 308, 1 to 3 conflicts with Heller, McDonald, and Bruen. It is void and unenforceable. The law must be immediately reversed and removed from Virginia law for several reasons. First, it violates fundamental constitutional rights. A statute that infringes a fundamental right cannot remain on the books, since its continued existence chills lawful conduct and invites unconstitutional enforcement. Second, it imposes criminal penalties on constitutionally protected behavior. Possessing a firearm is constitutionally protected, and criminalizing that conduct without due process is impermissible. Third, it creates unequal and arbitrary treatment, where two Virginians with identical histories may be treated differently based solely on whether one experienced a temporary mental health crisis, which violates equal protection principles. Fourth, it undermines public trust in mental health treatment. People may avoid seeking help for fear of losing constitutional rights, and this is a dangerous public policy consequence. Fifth, the statute is inconsistent with modern constitutional doctrine. After Bruen, states must revisit firearm disability statutes. Virginia's statute is among the most vulnerable because it lacks historical support and relies on civil mental health status rather than adjudicated dangerousness. Virginia Code Section 18.2, 308, 1 to 3 is unconstitutional because it deprives individuals of a fundamental right without due process and lacks any historical analog under Bruen. It imposes an overbroad status based disability, criminalizes constitutionally protected conduct, and conflicts with binding Supreme Court precedent. As a result, the statute is void, invalid, and must be immediately repealed or struck down. Its continued enforcement violates the Second and 14th Amendments and undermines both constitutional rights and public confidence in the legal system. I've seen Virginians lose their rights for decades because of one hospital stay. No violence, no crime, just a bureaucratic checkbox. And the people hit hardest? Veterans, trauma survivors, folks who did the responsible thing and sought help. This law doesn't protect the public, it protects the Commonwealth from having to think. And Lord knows thinking is not their strong suit. So what do? We fight it legally, publicly, and relentlessly. Petition for restoration. Demand legislative reform. Support constitutional litigation. Educate your neighbors. Shine the porch light on this nonsense until the roaches scatter. Rights aren't privileges, they're guarantees. And the porch light stays on until liberty drags its tail back home. You've been listening to the Porchlight Patriot. Stay loud, stay lawful, and don't let a bureaucrat with a clipboard decide your destiny. I have brought this matter to the attention of VCDL, and they are looking into it. I'd like to give a personal, heartfelt thank you to Mr. Philip Van Cleve for his dedication to protecting the civil liberties of Virginians from Chicken Pimp and all of us here at the Porchlight Patriot. Thank you, sir. I'd also like to encourage all my listeners to visit their website and see what they're accomplishing over there. Please make a donation to help them keep doing what's right. Visit them at www.vcdl.org.
The porch lights on.